Hello, doctors. I'm Dr. Chris Rapoff of EZQME Continuing Education, and welcome to this week's Case Law Update. In today's Case Law Update, we're going to explore Labor Code Section 3600, which, as you may recall, is in place to protect the rights of the employees and their benefits if they're involved in a work-related incident. Now, here we have the defendant contending that the applicant, in this case Mr. Lora, did not adequately convince the court that he had suffered a work-related incident. Therefore, the claim, according to the defendant, should be denied. After hearing the evidence and the facts of the case, let's take a look and see what the appeals board had to say about this very fact. Now, in today's case, in the Lora versus Rubio's Vineyard, the Workers' Compensation Appeals Board previously granted the defendant's petition for reconsideration. After their review of the petition, they indicated that the defendant is seeking a reconsideration of the findings and order, and that the workers' compensation judge had found that the applicant was injured in the course of and in the scope of his employment, and that the employer did not give Mr. Lora notice of termination or layoff prior to being informed of Mr. Lora's injury. Now, the defendant contends, number one, that Mr. Lora did not submit substantial evidence that he actually sustained an injury in March of 2018 as he had claimed. Additionally, the workers' compensation judge's original conclusion that Mr. Lora was in need of medical treatment, in the defendant's eyes, was not, quote, legally appropriate. Now, for some background, Mr. Lora had claimed that he injured his lower back while he was employed by Rubio's Vineyard in March of 2018 as a vineyard worker. In May of 2018, 2 months later, Mr. Lora received treatment at a local hospital's emergency department. There, he underwent a lumbar spine MRI, and they diagnosed Mr. Lora with acute sciatica and L4, L5, L5S1 disc protrusions with spinal canal stenosis. The parties proceeded to trial in December of 2020, 2 years later. Mr. Lora then testified that he injured his back in March of 18 while he was working on a fence and swinging a bar, which he hit a rock and cracked his back. Those were his exact words. Now, the issue in this case is dealing with the application of a post-termination affirmative defense under Labor Code Section 3600. We're going to discuss this now. Now, according to Labor Code Section 3600A, liability for compensation provided by this division, quote, shall without regard to negligence exist against an employer for any injury sustained by his or her employees arising out of and during the course of their employment. As you can see, Labor Code Section 3600 has a number of subsections as well. We're not going to belabor that, but just to review a little bit, they're talking about except for psychiatric injuries governed by another subdivision of a section, whereas the claim is in a compensation that's filed after a notice of termination or layoff, including voluntary layoff, and the claim is for an injury occurring prior to the time of notice of termination or layoff. No compensation shall be paid unless the employee demonstrates by a preponderance of the evidence that one or the more following of the conditions apply. Now, if you take a look at those, C seems to be the one that we would be looking at here. The date of injury is subsequent to the date of the notice of termination or layoff, but prior to the effective date of the termination or layoff. The case proceeded to trial, and during the trial there was no argument by the parties that Mr. Lora's claimed injury AOE-COE to his low back. However, the only issue that was submitted for decision was the post-termination defense. The issue of injury, AOE-COE, was not submitted for decision, and the findings and order does not contain a finding determining the issue of whether Mr. Lora had sustained an injury, AOE-COE, to his lower back. So they indicated that absent a finding that Mr. Lora had actually sustained an injury, the provisions of the Labor Code Section 3600, as we discussed earlier, would not be applicable and it could not be addressed. Now, the appeals board went on to discuss this and indicated that we do know that the employee bears the burden of proving injury by a preponderance of the evidence. In this case, it was determined by the infamous South Coast Framing versus Workers' Compensation Appeal Board decision in 2015. A preponderance of the evidence is defined by Section 3202.5 as evidence that, when is weighed with that opposed to it, has more convincing force and a greater probability of truth. When weighing the evidence, the test is not the relative number of witnesses, but the relative convincing force of the evidence. Hence, the purpose of the meeting of the causation requirement in a workers' compensation injury claim, it is sufficient if the work is a contributing cause to the injury, not necessarily a sole cause, but a contributing cause. And again, they reference the South Coast Framing case. Now, it's the applicant's burden to establish that industrial causation is reasonably probable. Additionally, for an injury to, quote, arise out of employment, it must occur by reason of a condition or incident of employment. That is, the employment and the injury must be linked in some causal fashion. The appeals board wasn't finished. They also indicated that where an issue is a matter of medical knowledge, expert evidence is essential to sustain a finding of injury. Lay testimony or opinion in support of such a finding does not measure up to the standard of substantial evidence. In this case, they're referencing Mr. Lora's testimony. The occurrence of an injury during a course of employment does not mean that it arose out of or because of that employment. Now, in the Lora versus Rubio's Vineyard case, the only medical evidence pertaining to Mr. Lora's injury claim was the May 2018 emergency department report from the emergency department physician, wherein the physician stated that, quote, the patient had a work-related injury approximately 1 month ago while he was swinging a tool and he was hitting a stone using a sledgehammer and pushed the hole digger building a fence. Clearly, the department's medical doctor's statement was based solely on what he had been told by Mr. Lora and nothing more. The appeals board now continues to school us in their decision. And they indicate that to be substantial evidence, and of course, these are things that we should already know, but these are always good review. An expert's medical opinion should be based on and must be based on an accurate history and an examination, and it must set forth reasoning to support the expert conclusions that are reached. They go on to say that a medical opinion is not substantial evidence if it is based on facts that are no longer germane, on inadequate medical histories or examinations, or on incorrect legal theories, or on surmise, speculation, conjecture, or guess. Further, they state that a medical report is not substantial evidence unless it set forth reasoning behind the physician's opinion, not merely his or her conclusions. We get back to the situation where your opinion has to be conclusory, but it also has to have the receipts as well. So you need to have your conclusions to be backed up by your information. Now here we have the emergency department's medical doctor diagnosing Mr. Lora with acute sciatica, L4, L5, L5S1 disc protrusions, and spinal canal stenosis. However, they pointed out that the doctor did not have the opportunity to review any of Mr. Lora's prior medical history and did not express an opinion as to whether Mr. Lora's symptoms were actually consistent with the mechanism of injury as claimed by Mr. Lora. Again, the trial record contains no other medical evidence pertaining to the cause of the lumbar spine condition, nor is there any evidence or testimony corroborating Mr. Lora's assertion that he had sustained an injury while working in March of 2018. As you can see from what we had just discussed in the prior slide, looks like the writing is on the wall here. And so the board continues by stating that they do have the discretionary authority to develop the record when the record doesn't contain substantial evidence that pertains to a threshold issue. They said Mr. Lora did have significant symptoms of an injury to his lower back, but the record did not contain substantial evidence as to whether his low back condition is or is not due to an industrial injury. So therefore, under those circumstances, they stated that it was appropriate to return the matter back to the original workers' compensation judge for further development of the record. Therefore, that they recommend that the workers' compensation judge schedule a status conference in order to help the parties undertake an efficient and equitable means of developing the record on the issues of AOE-COE. So accordingly, they rescinded the findings and order and returned the matter back to the workers' compensation judge for further proceedings that would be consistent with this opinion and issue a new decision from any of the aggrieved person that may seek a timely reconsideration at that time. So, to no surprise, the appeals board basically reminding us once again that a medical report as produced by a QME is not considered or qualified as substantial evidence unless it provides the reasoning behind a physician's opinion, not merely his or her conclusion, as we saw in this case. So in other words, the QME must provide the receipts in their report in order to qualify their opinions and conclusions as substantial. So once again, doctors, I'm Dr. Chris Rapoff and wanted to thank you for taking the time to join me in this presentation today. I hope you enjoyed it, and I look forward to sharing some other interesting cases again with you real soon. Thank you.